My name is Kiati. I'm the head of the firm of Joshi Advocates. Thank you very much for joining me in this video on Brexit EU settlement scheme, which is going to take effect from 31st of March 2019. The policy has been made public now, but its effect has not. So what that means is the general public can know what the law would be from March 2019, but this law and the application process is going through a pilot, which is a private trial process by the Home Office on certain people to see, what are the defects and whether they can iron those defects out before the whole process comes into effect in March next year. So what does that mean for you as European nationals? Well, it is actually very good news considering the position now. I will put the video below to inform you what the position is now for the European national to obtain permanent residence. Briefly to let you know, the European national has to, for 5 years, be either a worker, self-employed, self-sufficient with comprehensive sickness insurance, or student with comprehensive sickness insurance for 5 years. If there's a break of more than 6 months, it's difficult to establish that the European national is a qualified person and therefore lawfully resident in the UK for 5 years. However, once the Brexit takes effect 29th of March 2019, the European nationals have from March 2019 until December 2020 to submit their application for permanent residence or for pre-settled status. I will explore this in detail soon in this video, and their family members and how they can get residence. Now, let's first discuss European nationals and how they can get permanent residence from March 2019. All they have to prove is that they are eligible for permanent residence. What that means is that they have continuously resided in the United Kingdom for 5 years. That's it. That there is no criminal convictions or any bad behavior on their part. They provide their valid ID and they provide document support that they've been resident in the UK for 5 years. This could be HMRC proof or any sort of tenancy agreements or bank statements, proof like this to support that they have been resident in the UK throughout the 5 years. And that is all that they would have to provide to the Home Office. So there's a stark difference from what the requirement is now and what it will be then. So now the requirement is that the European national must be either working or self-employed or self-sufficient or student. Come March next year, that is not the requirement. Simply the requirement is that the European national has been living in the UK for 5 years by December 2020. So either the European national may make the application in March 2019, but no rush, because European nationals have until December 2020 to put their application in. Whether the application is for indefinite leave to remain, which is settlement status, or pre-settled status. The pre-settled status is that by December 2020, the European national does not have 5 years. So instead, the European national would go for pre-settled status. Right. So that's that. Now, the family members, people who are in the UK as the member, as the spouse or child or parents of the European nationals, and they themselves are not the European national. Now, currently the process is to provide evidence of relationship and to provide evidence that the European national was either working, self-employed, self-sufficient or student during the time of the relationship, or at least for 6 months prior to the application being submitted. However, come March 2019, the requirement is that the family member to simply show 5 years of being married, the Home Office to accept that the marriage is genuine, and that the family member provides the European national's original ID, and the person applying for residence to provide their original passport or ID. And that's it. The proof or evidence to support that the EEA national was working or self-employed has been taken off the table. So that's one. Now, one more is what happens when someone is divorced. You know, that's a good question. And interestingly, their answer is the same. Show that up to December 2020, you have lived in the UK for 5 years, and during this time, you were married for at least 3 years and lived in the UK for one of those years. So if you can show by December 2020 that you are married to a European national for at least 3 years and you've lived in the UK for 5 years in total when you make the application, then yes, you would be qualified for settled status on the retention provisions. There is no requirement to show that the European national was working at the time of the divorce. There is no such requirement as the policy stands now. I don't know if there are going to be any changes. Possibly there will be changes, I don't know. Let's see how the negotiations go with Michel Barnier, as they're ongoing at present. And considering this is just the legislation that has still to sort of have an effect on the general public, it has not been introduced to the general public yet. So wait, this video is simply to indicate to you that this is what's coming. And it's not all bad, considering what some of you have gone through, which is to show the European national's ID when you're divorced, to show that they are working or self-employed when you know the divorce has finalized and there are a lot of difficulties you guys are having. But all of that will be taken off the table, and simply to show relationship and original ID at least. Alright, well, for now, thank you very much for joining. I hope you find this video helpful. For further updates, subscribe and contact me if you need any further information. Speak to you very soon. Thank you so much for joining. Take care. Bye.